We're going to talk about plea bargaining a little bit. Plea bargaining is a valuable tool at the disposal of the prosecution. I think that's understood. And it's an accepted practice that prosecutors may occasionally use to bring a case to completion. What are your thoughts on when plea bargaining should be utilized?
Yes, plea bargaining, again, a lot of people have a misconception. It's has a bad connotation, I think, with most people, and I think it's just because they simply don't understand. Plea bargaining goes on in every office across the country, every prosecutor's office. If any prosecutor tells you that he doesn't plea bargain, then he simply isn't telling you the truth. Plea bargaining is necessary in order to keep the criminal justice system afloat with the resources that the county governments and state governments have. There can only be so many cases tried in a year. However, it's a good way for the prosecution to get a conviction. You may not get everything that you want, but you get an assured result, a conviction, and you also manage to save the budgetary expense of a jury trial.
1 minute.
Thank you. I believe plea bargaining is a necessary evil, but the factors that must be taken into consideration in plea bargaining are very important. First, the prosecutor needs to evaluate the strength of the evidence in each case. Second, the prosecutor needs to focus on the criminal charge and the severity of that specific criminal charge and take into account what type of plea offer should be argued. Third, the prosecutor needs to look at the victims and complaining witnesses, consider their concerns in the case. And fourth, the prosecutor should consider what the investigating officers have to do with the case and take all these factors into consideration and make a determination as to what an appropriate disposition is for the case, and specifically as to what cases should be a priority and what cases shouldn't. And depending upon the seriousness of those cases, some cases do need to go to trial. Thank you.
I have a follow-up on this, Mr. Weisman, that you can answer this first. In relationship to plea bargaining, do you think that victims of the crime should play any role in the plea bargaining process?
Yes, and during the past 5 or 6 years, and particularly in cases involving child victims or sexual offenses, I always consult with the victim or the victim's parents if it's a child and take their wishes into consideration. Sometimes I don't do what they want me to do exactly, but I tell them, of course, I'm obligated to do that, and they understand. I think they, I think their thoughts and their feelings in consideration, and sometimes, reliving the event and testifying just isn't worth it if you can get a conviction and get the guy sent to prison. May not be everything that you want, but so yes, I think it's very important in those kind of cases and other types of cases to a lesser extent.
Thank you. Mr. Rucker, 1 minute.
Yes, I do believe that it's important to take into consideration the thoughts and feelings in the case of the victim and the complaining witness. However, ultimately, the state's attorney and prosecuting authority needs to make a determination as to what is a fair and appropriate disposition in that case. Ultimately, the role of the state's attorney is to act as a role or agent of justice in each case, and the wishes of the alleged victim do need to be taken into consideration, but can't be the paramount and only concern, even if they are a very important concern. Thank you.
The next one's yours, Matt. You want to stay right there. Crawford County has recently instituted a state-mandated drug court, which the public may not know a whole lot about, but it is in place. The purpose of this program is to divert first-time drug offenders away from the mainstream criminal justice system into a process aimed at rehabilitation. What are your thoughts of this drug court program?
Well, I guess my thoughts are first, First, that it's been state mandated by the Illinois General Assembly, and of course, as agents and officers of the court, it's necessary to follow the dictates of the Illinois General Assembly. The drug court program was started here in Crawford County at the direction of the current surrogate judge, Christopher Weber. He implemented the beginning of the drug court program in January 2011. Currently, there are approximately 6 members in the Crawford County Drug Court, and that's the current number of members that the drug court is allowing at this stated time until the specific kinks are being worked out, and also getting staffing needs. However, I do think it's an important program to focus on that for non-violent drug offenders who specifically appear to express a desire to mitigate and end any type of drug addiction. And I believe that for those specific type of offenders, it can be a valuable tool and program with the intensive supervision of the drug court probation officer and then the counseling and treatment officer made it available, that can be a worthwhile program. Thank you.
Thank you. Mr. Wiseman, 1 minute.
Yes, as was stated, the drug court is more or less a mandated thing, and it is what it is. It's I suppose got its benefits. It's not something that that's going to be everybody's cup of tea or everybody's going to agree with. It is one way to, I think, address a person that has reached sort of the end of the line, and they know that the next step is I'm going to die, and as an alternative to that, try to get the intensive treatment. And so from that standpoint, I suppose it does have its value, although it has to be used in a judicious manner and not be allow that system to let people go unpunished.
Thank you. Next one, for your question, you'll have 2 minutes. Conventional wisdom says the punishment should be progressive in nature. Most people would expect repeat offenders to receive a harsher punishment each time they enter the criminal justice system. What circumstances, if any, would allow for a deviation from the idea that punishment be progressive?
Yes, that's a good question. That would be when there's probably a problem with the case, and that comes up from time to time because no one's infallible and no case is infallible. It's a necessary thing, I suppose, but by and large, the law enforcement that we have do a good job collecting evidence, interviewing witnesses, and we are very successful in getting that graduated, what I would call a graduated penalty, and if they have been in prison before, then they need to go back and for a longer period of time.
Carter, you have 1 minute.
Thank you, Officer Banks. I believe that a deviation from such a progressive system will be appropriate it'd be appropriate if such as someone's convicted of felony offense and they're convicted of a less serious misdemeanor offense. But other than that, I think that in the vast majority of times that it would be necessary and appropriate given the deterrent effect, necessary deterrent effect of the criminal justice system of having progressive and increased punishment, which is established and determined in the statutory fact of aggravation set down by the Illinois General Assembly. I know that I have heard some complaints when I've been speaking to members of the community that they don't believe that a sufficient progressive punishment system is currently in place.